Good morning, Judge Romero Garza. Juan Molina for the record.
Good morning, Mr. Molina. I'm trying to get this on YouTube. Stand by.
Okay.
Okay. Okay, for the record, this is P-40407. This is the estate of Raimundo de la Rosa. Have announcements, please, from lawyers.
For the record, Attorney Juan R. Molina from 710 South Texas in Weslaco.
San Juanita Sanchez, Your Honor, representing the applicant in this matter, Javier Villalobos.
Keith Livesay, also representing the defendant with Mr. Molina.
Okay, ladies and gentlemen, I had put a relatively short time period on the reset here, hoping that, and with the intent of make sure I get this back in Judge Garcia's hands as soon as possible. She is recovering, but she still didn't feel like she was ready to take on these kind of responsibilities. So we're stuck with a short date. I have a request for Eric Jarvis on the waiting room. Does he represent somebody? Do you know?
Yes, Your Honor. He has filed an intervention when it comes to the beneficiary Maximano de la Rosa.
Okay, let me let him in. Mr. Jarvis, good morning. Your speaker's muted.
Good morning.
Good morning, Mr. Jarvis. Welcome. I called the case. Ms. Sanchez indicated you've, well, I guess let me have you make your announcement.
Good morning, Your Honor. For the record, Eric Jarvis, we filed an intervention last night on behalf of Max de la Rosa, intervener.
All right. Mr. Molina and Mr. Livesay, any objection to Mr. Jarvis' participation?
None from our end, Judge.
All right. Okay, so I extended the TR. Mr. Livesay, I'm sorry. You were going to say something?
No, Your Honor.
Okay, stand by. Let me, Roel Garcia just entered the waiting room. Let me tell him that it's been passed. Stand by. Mr. Garcia. Good morning.
Good morning, Your Honors.
We were told that the patient is taking his medicine voluntarily, so everybody agreed to reset it till next Monday at 10:30.
Okay, that's fine.
Okay, thank you.
Okay, thank you, Judge.
Have a good day.
Happy New Year.
Thank you. Same to you.
Thank you.
Okay. So who has the burden? So I can hear the first word from that person, that side.
We do, Your Honor, on behalf of Mr. Villalobos.
Go ahead, Ms. Sanchez.
Yes, Your Honor. We came before this court and are requesting an injunction, Your Honor. This is based on a claim to that stemmed from a account that was established at the time that Mr. and De La Rosa and Ms. Quintanilla, before they got married and after they were married, there was a subsequent divorce that took place. And in that subsequent divorce, there is references to accounts being awarded to the defendant and awarded to the decedent. As soon as Mr. De La Rosa passed away, I'm going to say within 6 days, there was an account that had been established, and that was account number 0042108608. And in that account, there was approximately $275,000. And by December the 9th, Ms. de Quintanilla removed $250,000 from that account into another account And that account has since been depleted, and she took out the monies in the form of a cashier's check. Now, the reason that we have asked for an injunction is that that monies is the issue of the controversy at hand for this injunction. We are of the position that that money, which was removed, was wrongfully removed. It belonged to Mr. De La Rosa or to the estates. In the alternative, we have also spoken about the application of a section 123.151, Your Honor. But in the decree, very specifically, it states that any account that had existed prior to the marriage, in which Ms. Quintanilla signed off on that decree as an agreed decree, belonged to Mr. De La Rosa. We have had testimony in the first hearing on December the 16th, in which I asked Ms. De La Rosa regarding her knowledge of this account.
Judge, I'm going to object to any reference to the prior hearing. The court wasn't there. I mean, they're going to have to redo
And that's
any
fine, Your
evidence.
Honor. The court is asking for me to state what we believe to be the burden, and I'm stating to the court what we already have had. I will definitely take Ms. Quintanilla under questioning again and ask her the questions, Your Honor.
Is Mr. Quintanilla, she was ordered to appear and show cause why it shouldn't be made into a temporary injunction. Is she available, shall I say?
Yes, Your Honor, she is available.
Okay. All right. I'm going to call her.
May I proceed?
Yeah, go ahead. I'm sorry. Sure.
Yes, Your Honor. And so, and I will question her again. What I have is a decree. A decree is also seen as a contract, Your Honor. It is a contract that bound two parties upon signing that contract. And part of what was in the agreement in this contract was the division of accounts.
You froze,
Yes,
Ms. Sanchez. Part of what was is the last
Okay.
thing I got.
Yes, what the decree is, Your Honor, is a contract in itself. It is an agreement between two parties, Ms. Quintanilla and Mr. De La Rosa. In this decree, he was assigned all the accounts which existed prior to the marriage as his separate accounts. And furthermore, he was awarded, and Ms. Quintanilla agreed, that any account which he had sole control over would be awarded to him. In the same token, any that she had would be awarded to her. It is our position that Ms. Quintanilla, and upon questioning, if she testified the way she testified previously, will show that she did not have any control over this account. It'll also show that this account was specifically awarded to Mr. De La Rosa. The $250,000, which are in question, which are now in the hands of Ms. Quintanilla, are not in the rightful hands, Your Honor. We believe that because of the this decree and what was and being able to show that she had no clue of what was in here until he passed away, and she was informed of what this account was doing by somebody else, that she realized that there was an account with money, and she proceeded to take that account. We are here because we are of the position that it belongs to the estate, because it belonged and was rightfully under contract given to Mr. De La Rosa. And so our burden is to show that there is irreparable harm that will happen if she continues to hold this monies and depletes them. We believe that we can definitely prevail at the end of this under the trial.
Your Honor,
On the merits, Your Honor, and that irreparable harm may not be and that irreparable harm, Your Honor, cannot be compensated. And $250,000 was definitely not something she had and will not have if she spends that money to be able to satisfy any judgments against her, Your Honor.
Oh, hold on. Okay, Ms. Sanchez, to clarify for me, I noticed a new wrinkle here that I wasn't aware of. You said that Mr. De La Rosa and Mr. Molina's client established this account, this joint account, before they were married?
He had his account, Your Honor, since 2000. It was his account. Accordingly, in 2008, I believe, there was an addition to her on the account.
When were they married?
And I'm sorry, Your Honor?
And when were they married?
They married in, I believe it's 2009. If I can look at that decree real quick, Your Honor. Your Honor, I believe it was at 2009 when they were married, and they divorced in 2013.
Okay, that I wasn't aware of that. I don't know whether that changes the outlook of the account as being a account under that statute or not, but okay, then Mr. Jarvis, you having, I guess I align you with Ms. Sanchez's, I'll hear,
Position, correct, Your Honor. Yes.
go ahead, I'll hear from you if you want to add anything.
Well, no, I mean, I think it's simple in terms of, I have Mr. De La Rosa's son who takes under the will. He was not excluded under the will. There were two children that were specifically excluded. He was not. You know, this is his daddy's money at the time of his death. I think Ms. Sanchez articulated it quite clearly that at the time of Mr. De La Rosa's death, his ex-wife had no idea that there was money in this account, and she was informed by a third party. By the way, you're still on that account. She thought that was a fantastic bit of news, and she went and depleted it. It's a simple issue.
Okay, Mr. Molina or Mr. Lice, whoever.
I'll recap, Your Honor. Again, in order for the other side to prevail, which they have the burden, and it's a very difficult burden. First and foremost, again, I reurge the doctrine of collateral estoppel and res judicata because the Honorable Judge Rudy Gonzalez has already heard the same facts, the same issues, the same law. And Judge Rudy Gonzalez already made a ruling. So we're going to have inconsistent rulings. So in order for them to prevail, we have to modify Judge Rudy Gonzalez's ruling. Secondly, the will is very general, did not list the account. So you have to modify the will. Third, both divorce decrees, the one from 2002, the one from 2013, are very general, not specific. So we have to modify that decree. Next, this is a payable on death account. It's not a complex case for Eric's just so that he'll know. The beneficiary is Max, who we all agree is the biological son of the decedent, and the first Maria in his life, Maria de la Rosa, who passed away in 1995. Nobody's arguing that, but it's a payable on death account. So obviously we're going to object to any evidence contradicting the terms of the account. So they're trying to also modify the terms of a very simple account that banks like BVA Compass rely on for inter and interstate commerce and global commerce, to try to make it as simple as possible for customers and as reliable for customers. So again, modify Judge Rudy Gonzalez's decree, modify the will, modify both decrees, modify the payable on death account that clearly showed Max as the beneficiary and her on there as an or account. It was a joint account. Lastly, Your Honor, and I think most importantly, and I thank Judge Joanna Garcia, the probate court judge, and I also thank yourself as a judge for pointing out this law, which we were aware of, but the law clearly favors Fernanda, Maria Fernanda Quintanilla, and here's why. If you read the law in year 2015, when it got started, and then again in year 2017, it's very clear, Judge. And we cited that on something that we filed yesterday because it's important. Why is it important? The law is proactive, not retroactive. So by their own arguments, this law is not applicable. if you look at the clear legislative history, if you look at the law, this is a joint account, granted. Parties were divorced, and we get it. Nobody wants to see a laughing heir get something. It would be, as they say in Latin, contra bones mores et decorum, against the good morals of society. That's not this type of case. On the other hand, what this type of case is a case, if it were a criminal law, nolla poena sin lege, meaning you have the written law and it's supposed to be for the future, not for the past. So clearly, if we're going to follow the law, it's very clear. You can't look at divorces that happened in 2002, divorces that happened in 2013. I can go on. I mean, before the turn of the century, after the turn of the century, till you get to September 1, 2017. Okay? So that's why this is very important, because this will set a precedent, not just for this case, but for the hundreds of thousands of millions of cases that would flood this probate court when people get wind that this is what we're doing. So that's why I think this is very important. So obviously, we're going to object to any evidence contradicting the terms of the account. And then finally, Judge, I want to address this mystery, I guess, last modification or terms. I don't know of any docs signed by the decedent changing this account. And if there is some mystery account, that's why we pled the fifth out of an abundance of caution, because we thought, okay, well, maybe there is some mystery account. Certainly, we're not aware of any. Certainly, the records from BBVA that they supplied us, thank you, BBVA. We didn't have to go through the discovery process. They just gave us the docs that they relied on. They're not there. So if there is some mystery documents, I'd like to see them produced. Otherwise, I may have to just have a running objection on the Fifth Amendment right against self-incrimination, because Mr. Javier Villalobos in the first hearing with Judge Rudy Gonzalez said he had filed criminal charges against Maria Fernanda Quintanilla, my client. So we urged her out of an abundance of caution, we pled the fifth. That's our recap, Your Honor, with for now.
Ms. Williams, do you have language in the statute or case law that has discussed this applicability, retroactive, or when does it apply, to what accounts does it apply?
Your Honor, there is an objection to reliance on Texas State's Code 123.51 that we filed yesterday.
Okay,
And basically, it walks you through the law.
the statutory language.
Yes.
And do you have any case law that's interpreted?
Your Honor, there's not going to be any case law. We're in a pandemic. I doubt there's been very cases litigated. This is fresh law, but it's very, very clear if folks would take the time to read it, that it's talking about divorce decrees in the future. The effective date is September 1, I believe, in 2017. And Keith, correct me if I'm wrong. I know I read this Friday night and you saw this Sunday as well. We're both of the same opinion. If you want to opine, Keith.
Yeah, the judge, there was no cases decided under this statute, period. So there isn't any case law, but if the court looks at what we've referenced in our objection, it clearly says applies to divorce decrees after September 1, 2015, or divorce decrees after September 1, 2017. That's also consistent with the government code we cited that says specifically that laws are prospective as opposed to retroactive. And so this statute doesn't apply to this situation at all. And so essentially, they're asking this court to modify the statute and said, well, because under the divorce decree, this belonged to him, therefore we get it under the will, when under the probate code, a POD account is a non-probate asset and it goes according to the terms of the account.
And who would, so according to the terms of the account, how would the 250,000 be split?
Max would have gotten, Judge, his on the POD, as we discussed a few minutes ago, that there was no question that on this POD he would have taken.
Would it be a
Sorry,
non-probate?
I thought they were co-beneficiaries.
I think that they're
Your Honor, if
co-ben,
I may,
Yes, Ms. Sanchez. Whoever has the answer.
Yes, Your
who
Honor.
is-
I already gave the answer, but go ahead.
Who has the, I'm sorry, Mr. Williams, what did you say?
That the way it works, Your Honor, if you read the clear language, right? Basically, in order for under the that's why I was going to object to anything other than just look at the four corners of this contract. And again, as I mentioned last time, the BBVA Compass just recently sold for 11,500,000,000. Its net assets are like 339 billion. They've looked at everything, local, state, federal. They were aware of these of these laws, and they made a determination that my client Maria Fernanda Quintanilla was the recipient, and here's why. Let's assume that they were together and coming from Houston, and a Valley Coca-Cola truck would have careened into them and killed them both instantly. Then Max clearly would have been entitled to it as the payable on death beneficiary. But because it's an OR account and the way it was set up, my client is entitled to the funds. It's not just Juan Molina saying it, it's BBVA saying it after a
Objection to hearsay, BBVA is not party to this lawsuit.
well, it's factual that they tendered the money to my client Maria Fernanda Quintanilla. That's just the fact. That's why you're going after her, because they've already tendered the money to her via a
That's
cashier.
right, wrongfully.
Well, that's
I'm not persuaded by that. I mean, they have their own protective measures in the statute that may or may not be the basis for them having paid. If they feel comfortable under the safe harbor provisions, that's what they're deciding. I mean, but I'm not bound by their judgment about this. So you're saying that the 250 would all go to what ostensibly is listed as the co-owner?
correct.
Your
It's an
client?
OR account. Yeah, as last time I mentioned, Judge, this is an OR account. It's a joint account, multiple account. Those are synonymous. But basically, it's an OR account.
Your Honor,
Why does it go
may
to-
I-
If it's Homero Garza or Juan Molina, it's an OR account. We can both draw on the account. And the fact that I put money in, don't put money in, who cares? Ultimately,
What about the POD? Even there was PODs before this modification.
right. And what the legislature is trying to do is simplify things, Judge. But there's always going to, and what they're trying
That was a big
but-
substantive issue.
Yeah, but what they're trying to do is avoid exactly what's going on right here, right now, because it affects interstate commerce. And so when you do, you have boxes that you fill out. Clearly the payable on death was Max. And clearly, as again, we went through the whole bit last hearing with consanguinity. Why is that important? If it had been one of her two daughters, then she would not have been entitled to it. But that wasn't the case.
Your Honor, if I may, Your Honor.
Okay, go ahead, Ms. Sanchez.
Sir, Your Honor, under land grab, this is a 511 US 280. But in this case, the court looked at what was the intent of the legislation when they applied, whether something is to be applied retrospectively or prospectively. According to them, when we're reviewing a case, they stated that because it states that it'll be effective on a certain date does not suggest that it has any application to anything that occurred earlier. However, it did state in this case that the statute did not state anything specifically, whether it goes back or not, but just that it's effective was not enough for the Supreme Court to make a decision that it was not retrospective. They went on to the next requirement, and the next requirement is that if it were to operate, would there be a event that would be let me see, I got it specific here. Would it affect the rights of the party if it were to be applied now versus what it would have been before? In this case, and this is under land grabs, it states that would his right to recover be affected if we were to say that it was not to go to retrospectively affect, then would his rights be affected? His rights would be affected in the sense that he would not be able to recover because it would fall under 153. We're stating that he has a right to recover, and it is retrospective because it's affecting his ability to recover under the decree. Now, the decree is not going to be modified, as Mr. Molina stated. There's no modification of a decree at this point. What the decree would be enforced as a contract for what was given to Ms. Quintanilla, which should have been given to Mr. De La Rosa. He has a right to recover under a contract for breach of contract. And so I believe that when the court and Landgraf reviewed, they did not specifically state that and it's stated in this one that is retrospective or prospective. Construction does favor prospective, Your Honor, but like they said, there is no case law. There is no reason why we can't look at this in conjunction with a divorce decree to be able to state that my client, the estate, and Mr. Villalobos through the estate have a right to claim through a breach of contract and would be not able to if it was strictly applying only the 153, which would apply to Mr. Maximino. Our position is that we are affected by it and that we still have a claim under the decree. As far as res judicata that Mr. Molina stated, I think we've clearly stated that the 250,000 were not agreed upon. We're not part of the initial lawsuit in county court number 1, and that is why we're still pursuing 250,000 for this court, and is asking the court that the center of this whole argument is at $250,000. What we're here is asking the court to place those monies in an account with the court until we have a trial by the merits, Your Honor. Well, we can determine who this belongs to.
Hold on, Mr.
Okay.
Go ahead, Ms. Sanchez. Conclude your comments, Ms. Sanchez.
Yes, Your Honor. So we are in the position that the injunction which we are requesting would definitely be able to protect against irreparable injury. And that would be that having her money in her hands and depleting of those funds is a possibility. We don't know where the money is exactly. It's in her possession, Your Honor. And until we are able to do discovery, until we are able to get this before a court on the merits of it, that we need that money to be held at bay as through an injunction and in the possession of the court.
Ms. Sanchez, before I let Mr. Molina speak, my recollection is that Judge Gonzalez granted your TRO. It was just too late.
Yes, Mr. Villalobos was the attorney in that matter, Your Honor.
It was just gone by the time the TRO. So the last.
Correct, Judge.
I'm sorry, go ahead.
Your Honor, if the whole amount would have been there, the judge granted our TRO, but Ms. Fernanda had already pulled a cashier's check. She transferred it first from Mr. De La Rosa's account into a new account. We filed the TRO to freeze that new account. And when we had the hearing, she had already pulled 250,000 again in the form of a cashier's check. So when the judge granted our TRO, there was only 25,000 that he could freeze, which is the reason we're here. But he did grant our what we were seeking wrong.
Is that different from what I said? That Judge Gonzalez granted the TRO, just he didn't capture the money because it was gone.
It was gone.
Is that right, Ms. Sanchez? Is that
Yes, Your Honor, that is my understanding of what happened in that matter.
okay? Mr. Molina, go ahead.
Okay. Going back just real briefly, Your Honor, because you asked the question about the Texas Estate Code, section 123.151. As you know, it was part of the 84th legislature, SB 995. The legislation specifically states under subchapter D, chapter 23, 123 of the Estates Code, as added by this act, that it applies only to an individual whose marriage is dissolved on or after the effective date of this act. Again, SB 995, section 51. The effective date of that statute was September 1, 2015. Again, they're alleging, and they want to talk about the 2013 divorce, I'm assuming. Again, the law is not applicable. Likewise, 123, 151B as amended in 2017 as part of the 84th legislature. Again, it specifically states, Your Honor, that sections 123.151A and B of states codes as amended by the act and section 123.151C1 as added by the act. Here's the key. Apply only to a multiple party account for which the marriage of a party to the account is dissolved on or after this effective date. And the effective date clearly in black and white is September 1, 2017. So it's about as black and white as it gets. And I think they also, okay, go ahead.
Mr. Bonilla, so under the previous provisions for multi-party accounts,
Right.
why wouldn't it be split between the two beneficiaries under the contract?
Can you repeat the question?
Under the law for multiple party accounts before September 1, 2017, why wouldn't this be treated like the old POD accounts, which means that the two beneficiaries, the blood relative and the non-blood relative, would in fact get it under the contract? Why don't we go, if it's not applicable, why isn't the old POD law applicable?
Okay, a couple of things, Your Honor. Last time I pointed out two cases. The first case, which is really on point, Punts versus Wilson, and the other case was Stoudemire. And in that case, which is very similar to this one, they answered your question. And the answer to your question is they just want people to look at these POD accounts where you check off the boxes and you try to make it as simple as possible. And then you look at your legal, and again, I know that you know it's not a conclusion, right? That BBVA gave her the money, but they're not just going to give somebody $275,000 just for grins.
I don't want to talk about BBVA.
Okay. Well, here's the point to that.
What are the two sites on those two cases?
Do you have them, Keith? The Punts versus Wilson and Stoudemire?
Judge, they were cited in our objection, which to consideration of anything outside the POD account. So they're listed there. I will get the sites for you in a minute. Just
Okay.
So to further answer your question, Your Honor, we'll get you that case law. It's in the motions and pleadings that we filed. But when they look at this, right, and that's why they just want you to initial, if you want this to be a probate or non-probate matter, they want you as a customer to be aligned and understand exactly what you're signing. And he did. And again, Max is his bloodline. Maria Fernanda has daughters. Clearly he left Max, but he also left her. And in the boxes, and remember at the last hearing we went over the boxes, and clearly Max is the beneficiary, and you were wondering, well, who represents Max? Because clearly there may be at some point a conflict of interest between Susana and Max. I don't think so, because I think the law is black and white in terms of the beneficiary. So the answer to your question is, how did they handle this before? As you know, there's been a long history, right, with Texas State Bank and BBVA, Compass, and bank switching. But these forms basically have been around for a very long time, as you've noted. And these forms are supposed to be to make it as simple as possible. When you read it, you understand it, you get the money. And I get why the legislature did what they did. They wanted to try to prevent laughing heirs, people who get money and have no history with a decedent. Again, Fernanda and the decedent knew each other from the 70s when they worked with Liborio Hinojosa and Ruben Hinojosa at H&H Meats, and he was her boss. He was the plant manager. He was a very smart man. And so they ultimately married, divorced, which is not really relevant to this case, in my humble opinion. What is relevant is the state statute. What is relevant is the POD account. It is a multiple account. So the answer to your question is
Fernanda's your client.
correct.
Did she sign this agreement?
Correct.
The account.
Absolutely. Absolutely. She three things. One, she gave him her state issued ID then. She gave him her social. She's a signature on the account. It's clearly an or account. And obviously when she went to the bank, they got her state issued ID, which again, she was the La Rosa. She changed her name. Her state issued ID now says Maria Fernanda Quintanilla. Bank folks know this. They look at it and say, well, okay, are you the same? Are you Maria Fernanda Quintanilla that's in the account? Because I guess it could be confusing because the 1995, his first wife was also Maria de la Rosa. So you give them a state issued ID, you give them your social. Why do banks do that? Why do you do that in real estate transactions? Because that's what you need to follow the money. And so obviously they asked for her state issued ID. They asked for her social. They eyeballed her. They looked at her signature and they said, we're good, in a nutshell.
And here's my problem with that, Your Honor. I understand that Mr. Molina is very articulate when he says that the statute wasn't intended to create the laughing heir situation, and that's not what this is in his opinion, and be that what it may. But it's certainly not intended to create whatever the opposite of a laughing heir is. And I'm not going to say a crying heir, but Max is clearly Mr. de la Rosa's biological son, and we've already established that he would take. And in fact, I think that's where your question was going. What's wrong with the old POD issue? But Mr. de la Rosa, the decedent, it's absurd to believe that he gets a divorce and then after his divorce modifies his will to specifically exclude his now ex-wife, but then intends for her to raid the bank account to the detriment of his biological son. That makes zero sense.
Except for the fact that they had a unique relationship, Your Honor. In 2002, when they were married and divorced, they actually lived together. I don't know if
Your Honor,
Eric.
I object to that testimony. We've got two documents that have been signed by the defendant that are the issue here. Not what the relationship was, but what was
Do you
signed.
have the bank account where she signed, and do you have the bank account where
I have, Your Honor,
she's
there,
listed as a core account?
Mr. Molina
That's
states,
relevant.
Mr. Molina states, she got a divorce, she changed her name. She was adhering to the divorce decree. She relied on that. We're stating that what he's overlooking here, that there is an agreement that was signed. She signed a decree as agreed. She understood and should have understood, because she was represented by an attorney when she signed this decree, that it was going to bind her and bind Mr. de la Rosa as to what the assets were. And so therefore, we come back to whether it is a state's code or not, but the fact is that there is a document that in the law is looked as a contract, and that is a
Your Honor, if I may point out something.
divorce decree that can give us Mr. de la Rosa's estate, the right to sue for breach of contract, Your Honor. And that would be for the monies which were placed in this account, which was not given to her, but given by agreement by the parties to Mr. de la Rosa.
Your Honor, if I may ask a quick question,
Yes, sir, go ahead.
because I want to try to clear up something. Eric, in the first divorce, you represented one of these parties. Do you remember that? You remember if you
A while back, yes, sir.
Who did you represent?
I think it was I divorced.
I'd like to get that cleared up, Your Honor, because it might create a further conflict of interest, because he actually represented one of these parties in 2002. So I'm just relying on memory.
Right, and your memory, Juan, is better than mine right now because I remember an issue way back nearly 20 years ago, but I don't remember.
Mr. Molina, are you, I don't know what the right word is, alleging or asserting that Mr. Jarvis represented your client in that?
I just want to clear it up, and I haven't really researched the ethics or the conflict of interest situation that all this might arise.
Factually,
And again, I just bring it up as an officer of the court.
factually, are you asserting that that Mr. Jarvis represented your
Your
client?
Honor, he did
I don't
not
know. I don't
represent Ms.
remember. I just
Quintanilla.
remember
He
reading it.
represented the
I
decedent.
can't get all of you. You're all bunching up. Gonna have to do it one at a time.
I
Your
just
Honor,
wanted to ask Eric if he remembered, because I read a lot, and I remember in the first decree, he was involved in it along with Katie Henley. In the second decree, obviously there was different lawyers. That's all.
Your
Judge.
Honor, if
Thank you.
I have submitted the decree for use as evidence. It is in the court's records, a certified copy. I can share it with the court and show the court that Mr. Jarvis represented the decedent, not Ms. Quintanilla.
Sanchez, how do you respond to the assertion that the statutory language says it applies to divorces after that date, the 17 date, September 1, 2017? Why doesn't that throw out that statutory language?
Are you asking me, Your Honor?
Yes, Ms. Sanchez. Yes.
Your Honor, the statutory language would come to the POD and it would come to who would be the beneficiary.
Okay.
As anything that happened in this, anything that triggered happened after the Mr. De La Rosa passed away, which brought into question who was the owner of this account, because there was absolutely no handling of this account by Ms. Quintanilla, Your Honor. It was only my client, not my client, but Mr. De La Rosa, in the entirety from the time of divorce until the point of her taking the $250,000, the only deposits and the only activity that was put into this account came specifically by Mr. De La Rosa, nobody else. And this is years after the divorce. That being said, he was the only one, Your Honor, that had access to it. Now, if it's saying that because does it come after? And if it comes after, does it belong to Mr. Maximino? That's to be determined, Your Honor. And that's why I'm before this court stating that right now we're not on the trial of the merits, but we're here to put an injunction on this until we're able to sort this out. And I believe that my client, which is the estate through Mr. Villalobos, has a possible claim, Your Honor, and a probable claim of breaching of a contract. Now, if Mr. Maximino wants to argue that he would take under it, then he too would not need to be able to show that and be able to show that how the effect of it was on him after this enactment. And I go back to the land graph that states that the statute, because it says it was only effective as of one date, does not in itself have an effect if it's going to infect my client, which is the estate, and Mr. Villalobos, as to what is rightfully the estate's property.
Okay, Mr. Molina, Mr. Jarvis, do you want to say anything before I let Mr. Molina or Mr. Lifesay have the final word? I'm sorry, Mr. Jarvis,
I'm fine. I think.
Mr. Lifesay or Mr. Molina, before I give Ms. Sanchez the final word.
Well, let me add a few things. First of all, let me cite to the court the case of Mollett versus Kimbrell. That's at 356 Southwestern 3rd, 407. And that was the Texas Supreme Court in 2011, says the courts do not consider legislative history when the statute is clear. And we have cited the clear language of the statute concerning, isn't just a question of effective date, it's a question of, it says it does not apply to divorce decrees entered prior to the effective date of the statute. I don't know how they could have made it clear. And so that issue, that issue is gone. The second issue, which I think and this goes to what Mr. Jarvis was saying, and then the cases I would cite to the court are Stafford versus Henderson, and that's at 801 Southwestern 2nd, 858. And does the court have Punts versus Wilson, which is at 137 Southwestern 3rd, 889? And then let me give the court another one, Sheffield versus Estate of Dozer, 643 Southwestern 2nd, 197. And the Supreme Court has addressed this issue. It says in it that you don't look at the subjective intent of the testator. It's sort of like someone coming in and saying, well, this is a bad will. I don't think this is what he wanted. Well, you know, can you prove undue influence? No. Well, I just don't think it's what he wanted. Well, you can't go against what's the written will. These cases apply that to the POD situation. You can't go contrary to the terms of the POD account, basically by saying, I don't think that he wanted to do that. And you can't do that based on their premise of, oh, he owned the account. Well, yes, he owned the account under the divorce decree, but we're not here saying, well, did he own the account or did he not own the account? We're here saying, what did he want done and the conclusion of his life on this earth? It says P.O.D. Maria Fernanda. And so she gets it, and the court is bound by the terms of the POD account. So this is basically, and then, so they cannot prove a probable right of recovery. It's a question of merely looking at the document, the four corners of the POD account, which says that she gets the money, period. And then this is just like accumulating a smoke screen saying, well, he owned the account, we got a divorce decree, we have a breach of contract. Well, they didn't even plead breach of contract. They said conversion. They said she stole the money. And so again, it's just very simple. We look at the POD account, it goes to her, that's it, the end of story.
So as a consequence of the divorce, who is the owner of the account?
That's, I mean, he's the owner under the divorce, but that's irrelevant. If under, that's sort of the point of a will, is that you can dictate how your property is going to go that you own at the time of your death. And the legislature specifically authorized POD accounts to do the exact same thing. And that's why they're classified as non-probate assets. They go pursuant to the terms of the account. So, you know, it's that claiming the ownership is a red herring, you know, and it doesn't provide the necessary element of proving a probable right of recovery, because they have to prove that he did not want that money to go to Fernanda, and they can't do that because it violates the parole evidence rule, statute of frauds, because it's not what's in the terms of the POD account.
And the beneficiaries under the POD account, or tell me again who they are?
That it's Fernanda, and then the contingent beneficiary is Max.
Okay, now I haven't seen, I thought all I saw was one where it has Max Jr. and I thought it was the daughter from your client's daughter.
No, Your Honor.
No.
What was all the blood conversation about then? One was related and one that wasn't. Is that the wife?
I think that was
The
about
wife, Your Honor, is on this. And-
So
and
the husband and the wife left. Okay, then I need to look at the POD account again. I'm very confused about it. Okay. Which of these three cases, which is most applicable to a POD account under the old language?
Probably Punts versus Wilson, but I'll defer to Keith.
Yeah, I'm gonna, all three of them applied under the old language. the statute was not in effect for any of these three cases. In the Sheffield versus Estate of Dozer, they did precisely what Mr. Jarvis asked this court to do, to look at the the intent of the decedent, and the Court of Appeals, the trial court did that and let the jury determine it, and the Court of Appeals reversed them. I would say, that you look at the Stauffer versus Henderson is very clear application of the parole evidence rule, and Punts versus Wilson is the most clear application of how has been applied most recently.
Okay. Sanchez, I'll give you the final word.
Yes, Your Honor. In the words of Mr. Lifesay, a contract must be looked at four corners of what was in there and not intent. That is the same way we look at a divorce decree, Your Honor. It is a contract, a binding contract. And in this binding contract, entered with a signature also as an agreement between him and the defendant, Ms. Quintanilla, he was awarded this account as his assets, as separate, which is the first section. He claimed it as a separate property, and then he claimed it again as being in sole control. Looking at this contract, that he is stating there's no intent to be looked other than this is what he and her agreed to. In the will, it passes through, he specifically states properties, and then puts in his will anything that would fall within outside of the specific bequest he gives into the residual of the estate, which is where this would be, Your Honor.
If he was the sole owner, then his will would distribute it between his son and.
Absolutely, Your Honor. Absolutely. And as far as whether we've pled or not, any of our pleadings can be amended to continue including, and as we're finding out through this process, is that we have definitely an issue, a claim, Your Honor, on this account because of what was rendered. There's actually representations or references in the estates to the family code for the marriage and dissolution under section 9.001 in other cases when it comes to the will. So because there is no case law, I think that we also have a right to be able to try what this was stating, Your Honor. We are, as Landgraf says, they have not met to be able to say that this does not apply retrospectively. I think that's still an issue, Your Honor. And while we're resolving these issues under this law and under the decree, this money needs to be held abated with the court. This injunction needs to be given, and we should have that money in the court's registry because we believe that there will be irreparable harm, Your Honor, and that she does not have the ability to replace any of this monies for final judgment. And until we're in the trial of the merits, it needs to be held in the court's registry.
Ms. Sanchez, have y'all had the occasion to review the safe harbor provisions that gives the BBVA Bank protection from liability? My recollection, have you done any of that work?
I'm sorry,
Has
Your Honor,
BBVA told you?
you broke off, Your Honor. I'm sorry.
Has BBVA told you what statutory language they're relying on to assert to you that they're not liable because?
No, Your Honor. There has not been any discovery or BVA has any input in this lawsuit that we're in right now, Your Honor.
Okay, well, that will play itself. That will play itself out. Mr. Jarvis, anything else you want to add?
No, Your Honor, I think we're pretty clear on everything.
I had said this with a really short timeline because I was hoping that Judge Garcia's would take this back because every time I hear about the case, it seems to get more complicated as I hear more and more arguments. So I'll stay with it for now. I'm going to read those cases and I'll review the statutory language. I guess if I can get proposed orders from both sides as soon as possible, that'll help me.
May we get excused, Your Honor?
I'm
May
sorry?
we be excused?
Yes. Anything else?
Well,
No,
Judge,
I've already
all right, Judge, do you have access to Westlaw?
sent a proposal on the injunction order.
Okay,
I
Judge,
can't get the case. I got Texas Bar CLE, that free library. I can get the cases.
okay, can you get the legislative statute, the session law
Yes. But-
Okay.
yeah.
I mean, if you can't, I don't have a problem providing that to everybody.
Someone provided it to me, and actually, I've already accessed it and looked at it. It's just, I have that, the statutory language. I've never, no one has focused the applicability date language to me yet, so I'm really focused on that.
Okay, that's at the bottom, the last part of the statute as it is in blacks, and then we set out the sections in the sessions law where it was enacted.
Okay. Ms. Sanchez, you wanted to ask something or say something?
No, Your Honor.
Okay.
That concludes our testimony.
Okay, thank you all. Appreciate it. You all have a nice day.
All right,
Thank
thank you,
you,
Your
Judge.
Honor.
Bye-bye.
Hold on, Roland.
Take the YouTube off.
Yeah, that's what I'm trying to get to.